This video is about the essential understanding of manufacturer consent and ultimate consent, which is presumed and implied to have already been given. Contracts which the corporation has already entered your agreement to. And your agreement, whether by your consent, being informed or implied, requires a resignation of that consent in writing. Failure to present and register your opposition to the consent by registration, which is presumed to be held by the courts and the jurisdiction of the corporation and the state which you reside, held until that resignation of consent is given. Failure to give and present that demand and resignation of your consent keeps you entrapped within that corporation bounds and subject to the jurisdiction thereof. Essentially, the 14th Amendment. Here we're going to hear a Supreme Court argument that was heard last November 2022. And this court case is vital to understand the consent which is manufactured based upon the implied consent, absent the constitutional conditions that are required for obtaining that very same consent. So let's take a look at the case overall. Here it goes.
Railway. Mr. Keller.
Mr. Chief Justice, and may it please the Court. As far back as 1827, states enacted laws like Pennsylvania's, and by 1868 or shortly thereafter, every state in the Union had at least one, and often several, consent by registration statutes. This Court unanimously confirmed that such statutes comport with due process over a century ago, in reasoning that's been embraced by jurists from Holmes to Cardozo to Hand to Frankfurter. With history, tradition, and precedent on Mr. Mallory's side, how can my friend challenge Pennsylvania law under the original meaning of due process? By claiming that these statutes were really just about specific jurisdiction based on contacts. Never mind that specific jurisdiction wasn't a thing in 1868 and for decades after the 14th Amendment was ratified. Anachronistically, importing the principles of international shoe into the ratification generation is my friend's maneuver, exactly what Justice Scalia counseled against in Burnham. That approach is not originalism. It's paying lip service to originalism, treating the doctrine as an infinitely malleable pretext to reach a policy outcome that Norfolk Southern and other big businesses prefer. But originalism is not a pretext. It's a neutral doctrine that aims to faithfully apply our nation's Constitution regardless of who benefits. Fidelity to the original public meaning of the 14th Amendment in this case means that the flesh and blood little guy wins and the Fortune 500 company loses.